Good day, class. So, today we will be looking at the next module of lesson. We will be looking at module 1, which we will be where we will be exploring one singular topic, and module 1 will be split over two different sets of lessons. Okay, so this will be the first part of the first module, and a later video will describe what will be happening in the second part of the first module. So what are we looking in module 1 over here? Well, basically we will be talking about arbitration, what it is, what is arbitration and conciliation, who an arbitrary umpire is, or arbitrator or an umpire is, what is meant by order of reference, selection of arbitrators, the powers and duties of arbitrators, and the arbitration award and implementation of it. All right. Now, these are the things that are largely described in the syllabus. So, here, as a part of the first one, what we will be doing is looking at arbitration and conciliation, what it means, we'll try to look at who the arbitrator is, and we will also look at the order of reference. So the first part of arbitration is what we will look at over here right now. Important questions to ask. Why do disputes arise? What are some common disputes which are seen in construction contracts? What are the modes of settlement of such disputes? What are some key definitions relevant to the processes of arbitration? And what are conciliation and mediation methods of dispute redressal? Okay. So, now to give you a basic introduction over here, we understand that for as long as human beings have been alive, there have been disagreements and a disjointed method of, living with each other. So at some point where somebody has a dispute with another person, you either settle it in an old-fashioned Neanderthal way where you punch it out and one person dies, or you look at it in terms of keeping an orderly civilization going on. All right. So, at least in that sense, what happens over here is that we have seen dispute settlement as existing from a very early time in our civilization. In India, the system was widely practiced for dispensing justice as a part of the village council or the panchayat. So, generally, all the issues that used to happen as a part of this was a part of the village council or the panchayat. All right, it would be referred to the village council or the panchayat, and it would be easily resolved over there. So the nature of the disagreement or the dispute would be simple and cannot be. It need not go to a higher order of court. It need not go to the regional levels of governance. All right. So during the early British period, regulations encouraged arbitration for amicable settlement of disputes. All right. So from previously also, there were plenty of regional legislations which oversaw how arbitration worked. Now, overarch all of these, we had the Arbitration Act of 1899 passed, where small gaps between which would occur between the legislations of these particular regions was filled by this act. as we reached the first half of the 20th century, we had the Arbitration Act of 1940, which was enacted as a full code on arbitration in India. Now, there was a problem in this Arbitration Act because it did not set limits in terms of when and how a court of law could get involved over here. So, when we talk of arbitration over here, it is an act of settling an argument without having to go to court. So, the problem over here, as a part of this Arbitration Act of 1940, was that it did not delineate a limit where courts could come into the arbitration process. So you would have the arbitration process happening, and because one or the other party involved in the arbitration process would have approached the court would intervene. All right. So these are generally seen as a very disruptive practice, and they disturb how arbitration works. Okay. So as a result of this, to replace the Arbitration Act of 1940, the Arbitration and Conciliation Act of 1996 was enacted. This is based upon model rules prescribed by the United Nations Commission on International Trade Law, 1986. Again, the thing about arbitration and conciliation is that it can apply to disagreements or disputes beyond the scope of commercial establishment. So if there is an arbitration required between, while the basis of the disagreement will be financial or based upon the provision of a service or completion of a work, largely what happens is that you will be encountering arbitration proceedings between individuals. So it does not wholly cover only commercial aspects. It can also cover personal aspects as well. Okay. So here what happens is that this act provides for domestic arbitration, international commercial arbitration, and the enforcement of foreign arbitral awards. So since it has been modeled upon the Commission for International Trade Law, what it does is that it has a sort of an equivalence to the kind of arbitration which would have happened in different other countries. Okay. And as a result of that, it allows for this act to cover enforcement of foreign arbitral awards. Okay. Between companies which are not based in India and companies which are based in India, as a simple example. The next thing we have to look at is the question, why do disputes arise? So here we need to know that disputes are inevitable in any contract, as the interests of the parties involved are at variance and all contingencies cannot be foreseen or provided for in a contract. So basically what this comes to say is that you cannot expect the interests of the parties involved to be in confluence at all points of time. At some point or the other, they will vary. They will go in two different divergent directions, and that may not be ideal for the purpose of the common good. All right, the common good being the activity they both have embarked upon. And also, what happens is that if let's assume that the common good is still being maintained, all contingencies which may occur which hamper the execution of the common good, those cannot be provided for. Contingencies are basically these small little problems or things which may crop up in the process of in the timeline of any process that you will be taking up. Say for example, let us say that you have to travel from college and you have to go to Kormangla. Now, how would you describe how much time you would take to go from college to Kormangla? You would probably end up saying that you will get there within half an hour, inclusive of traffic contingency. Now, traffic contingency is basically a factor which can vary, which you do not have any control over, and which can vary, which will adversely affect how you go to a particular place. At least in this case, we're talking about it as you going from one place to another. So traffic contingency is where you are talking about a certain unpredictableness of the traffic that you may encounter. But while you are traveling, it is fairly clear that this is the this is the target, this is the thing that is about to happen, and these are the contingencies that may crop up as a part of this. All right, travel being the activity and the traffic being the contingency, correct? So in a construction contract, or in any contract for that matter, all contingencies cannot be considered. All right, all contingencies cannot be foreseen. So what happens when such contingencies, things which you would have never predicted, start happening? That is where we start looking at arbitration as an exercise. Okay, so some common reasons for contractual disputes are as below. Actual intent of the parties is not reflected in the contract documents. So from the previous semester, we have already seen that contracts have to be crystal clear in terms of what is being offered and what is being agreed as a part of the contract document. So let's say a party agrees to pay a certain amount of money to another party for the completion of a particular service. Now, we are talking about it in exact particulars here. If the language of the contract does not specify what amount is being paid and does not specify what service is being provided, that can be considered as the non-reflection of the actual intent of the parties. All right. Now, this happens either because both the parties are not sure about what they are doing, or it happens because there is a vagueness in the language that is being put across as a part of the agreement. So, if someone is drafting the agreement, if they purposefully put in vague language which do not define exactly what are the duties and responsibilities of each party, then this becomes a factor for a dispute to arise. Okay, because it becomes very contentious because neither party knows what the other party is responsible for. So it starts a blame game. You start pointing fingers at one another. All these kinds of things may end up happening. This is the most common problem. So you have delay in the fulfillment of either party's obligations. So either one party which is providing a service does not provide it within a particular time, or the other party does not does not pay for the services which are rendered within a specified period of time. All right. So in both these cases, what happens is that the other party will always suffer. If the person offering the service does not finish the service in time, the other party will suffer economic damage because he is not able to use that. So he's not able to use that service and put it to work in terms of benefiting him economically. All right. In the case of the one party refusing to pay the other one in time, it basically means that he ends up taking a lot of credit. Ends up taking a lot of interest on the credit, and therefore his profits start getting eaten into. All right. So in both ways, the other party suffers damages. Okay. Scope variations and inadequate compensation for the same. So verbally, if something is agreed upon, and as per the contract it is also agreed upon, but there are some scope variations which come up at a later stage because of whatever circumstances, and there is inadequate compensation for the same. That is where we have these kinds of disagreements, where you have disputes. So let me say, for example, over here in a construction contract, if you have been commissioned to build, let's say, an RCC staircase, but due to cost constraints, due to space constraints, you end up building a composite staircase. The scope has completely changed, right? And the cost may not be the same for the composite staircase as it may be for the RCC staircase. So there may be an increase in the cost, and the person liable to pay refuses to pay it. So this will cause a dispute. In this case, one-sided conditions of the contract are basically those which favor one party over and above the other party. Okay. So the idea of all contracts is that there has to be some equity. There has to be some um, parity between the two parties in terms of what one person is offering as a service and how much the other person is paying as fair market value for the offered service. All right, so it's important that we know that we know what fair market value is, because that is what holds good as a part of equity. Okay, so in construction contracts, what are the causes for disputes? We talk for compensation for delay arising from client faults. Client faults basically are a lack of providing a clean site in time, which we talked about as a part of your tenders, not providing proper tender documents or working drawings, right? Not providing for sufficient ground testing or soil testing or structural testing, which are absolutely essential as a part of the um, site analysis. Again, we talked about scope variations, and I gave you an example of how scope variation occurs as a part of construction contracts. We talked about interest claim for delayed payments. So here what happens is that the contractor is the one who will be asking for the payments. So if the client refuses to pay in time, the contractor suffers losses in terms of the amount of money he has blocked for the use of equipment, the use of people. All right, so he has to end up paying interest on that, and that interest he can transfer upon the client. This is where a client can levy liquidated damage for delay in completion of work. So liquidated damages are basically those damages which are not quantified, not quantified by an amount of money, not quantified by an amount of money, but they are estimated as a cost because of the delay that would have occurred. So let me give you a simple example over here. A liquidated damage would be a compensation which can be asked from a contractor who is, let's say, building a hotel. Okay, the liquidated damage will be the a certain amount which will be adjusted against a projected loss in terms of business if it is a hotel, right? Hotel, restaurant, anything of that sort. So if a restaurant is scheduled for a date X, scheduled to finish by date X, and have an inauguration immediately after that, but instead gets delayed by around 2 weeks, those 2 weeks can be quantified in terms of a certain amount of money. That amount of money is called as a liquidated damage. All right. Then there is some compensation which has to be done for delay in decision making. All right. So if there are acceptable scope variations within the same agreed compensation, but the client does not make the right kind of decisions within a fixed period of time, what happens is that the contractor has a lot of people who are stuck on site, and they have to wait for instruction before they start the work. So just because they're stuck on site and not doing work doesn't mean that the contractor does not pay them. So he has to pay them for the extra days which have been wasted, and he has to pay them for the days where they work. So this compensation for the days where they were sitting around doing absolutely nothing can also be taken as compensation. All right. Liquidated damage, again, we could talk about compensation for delay caused by contractor. That again falls into the category of liquidated damages. Substandard work can also be a cause for dispute, and the contractor can be held responsible for fixing substandard. And if he doesn't, again, it starts causing a dispute over here. Then we talk about unrealistic estimates or too much deviation from the estimated cost. This kind of problem occurs where we talk about lump sum contracts. So a lump sum contract basically estimates upon a certain set material palette. All right. Now, if you deviate from the material palette and have inordinate changes in the costing, this creates a deviation. All right. And the client needn't necessarily entertain your claim for a payment. So this again will start causing a dispute. Okay. Poor mobilization of resources. This again is a problem which is attributed to the contractor. If he is unable to mobilize resources within an acceptable period of time, so he may be charged for not starting the work on time. So now that we have seen what are the kinds of disputes that may occur as a part of general contracts and construction contracts, we start looking at the ways in which these disputes can be settled. Okay. The idea of dispute settlement is to ensure that there is a smooth progress of work. Because leaving aside the fact that you may not want to work with that other person again, it is also important that your work does not get stuck somewhere in the middle. So it is absolutely essential that we broach some sort of a compromise and get back to work. All right. So we talk about 5 common dispute resolution methods over here. These are again very legal. These are legally driven dispute settlement methods. The first one is capitulation. This is where the weaker party gives in to retain goodwill and long-term relations with the stronger party. Okay, so this isn't necessarily the most ideal situation. Of course, if this generally can also be termed as a toxic relationship, but here what happens is that the weaker party identifies greater long-term benefit by retaining goodwill over here. So therefore, they give in terms of the negotiations over here to the stronger party's wills. Okay. The next one is negotiation. So both parties try to sync their differences and come to an amicable settlement. Most international disputes regarding borders, regarding nuclear weapons, all of these are sorted by means of negotiation. All right. Most common example being the North Korean summit with Donald Trump. Ironic, because neither of them are great in negotiations. But again, that is an argument for some other time. The next method is what we will talk about in extension over here as part of this lesson as well as the next lesson. Arbitration is where a neutral third party is appointed to adjudicate between two parties who are disputing. Fourth is litigation. Litigation is basically dispute redressal in a court of law. This is generally not preferred due to abnormal delays and heavy expenditure. The idea is basically taking someone to court for civil disputes or criminal damages, whatever it is. So the idea is that you litigate it in a court of law. The fifth one is a dispute resolution board. This is basically a board which is constituted at the time of the contract to resolve disputes as and when they arise. So, in all of these, in the first four that we noticed over here, there would be either a provision for the for negotiation or arbitration or capitulation or litigation as a part of the contract. In the case of the fifth, what happens is that there is a board which is already constituted by the two parties who are getting into the contract at the time of the contract itself. And they are saying that anything that happens, any problem which we expect to show up, has to be referred to the dispute resolution board. Now, the idea behind this is that both the parties do not trust each other to do the work in completion without a problem or dispute, or they definitely expect some or the other dispute to crop up because of the actions of one party or the other. So, as a part of that, as a simple way in which to deal with such things, the dispute resolution board is constituted at the time of the award of contract itself. So, why do we choose arbitration? It's considered as the most popular mode of settling disputes regarding building and engineering contracts because it imparts speedy justice with minimal expense. So every dispute that goes to a civil court may be first referred to arbitration because going to court, spending so much money in terms of litigation generally ends up costing a lot of people a lot of money. Okay. And it cannot be considered as a viable method to solve a problem. So the benefits that we look at in terms of arbitration: lowered cost. You don't have to pay for your lawyers. You don't have to pay court fees. You don't have to pay stenographer fees. You don't have to pay court scribe fees. There are multiple costs which are associated with the court process. Okay. In the case of arbitration, you have already agreed that your first recourse will be this process where you come to an amicable settlement. Okay. And since it is isolated, it is something which is focused exclusively upon you, there will be a faster conclusion of it. There is certain privacy which is maintained as a part of arbitration proceedings. In the place or in an open court, what happens is that privacy is not a guarantee. All right. Generally, everyone knows what is happening. In an arbitration, the processes can be a little less formal. They don't have to follow the strictures that come along with a court process. Here we can come up with creative solutions and settlements. And you also have a better control over the outcome. Because in the case of a court, what happens is that a judge may not be fully informed in terms of what the arbitration is about. But in the case of arbitration over here, the person who is called in as an arbitrator knows exactly what is the problem being debated, and there will be a better understanding and outcome for the process. Also, this gives you a little bit of flexibility to conduct the process at your own ease. Now, next we look at the Arbitration and Conciliation Act, which we talked about as a part of your introduction. Okay, so all regions which come under the jurisdiction of Indian law, are subject to the Arbitration and Conciliation Act 1996. This includes the 29 states and the 7 union territories. So the main objectives of the act are as under. So it covers international, commercial, and domestic arbitration and conciliation. It provides for fair, efficient, and customizable arbitral procedure. It ensures that the arbitral tribunal gives a reason for its award. To ensure that the tribunal works within its jurisdiction. To reduce the supervisory role of court in the process. To allow the tribunal to use other alternative dispute resolution methods available for the settlement of dispute. To ensure that the arbitration award is enforced in its full and in a manner similar to decree of court. And to ensure that the settlement agreement agreed by parties involved as a result of conciliation proceedings will have the same status and effect as an arbitral award. Now, in the previous term, in the last term that we notice over here, we talk about something known as conciliation proceedings. Now, that comes as a part of something which we talk of as mediation and conciliation. Now, what is mediation? It is basically a process involving chosen intervention by a neutral person appointed by both parties to settle a dispute. This person is known as a mediator, and he enjoys the confidence of both the parties, and he possesses expertise in the subject. So let us say you don't want to go to the extent of arbitration. You would rather mediate and have somebody come to get you both to the table for a compromise. So that is where a mediator comes into play. All right. So the mediator enjoys confidence of both the parties. He is known to both of them, and he possesses expertise in the subject. Okay. In this process, what happens is that both parties will tell the mediator exactly what are the facts of the dispute, but they do it in the absence of the other. Okay. After hearing both the parties, analyzing the facts, the mediator will decide what the relative position of each party is in the dispute. Okay. So once the mediator does this, he will say that he will determine exactly what each party's role in this entire process is and come up with a decision which seems fair for both the parties concerned. All right. But it should be noted here that the mediator is not an arbitrator, and the signed agreement by both parties in the presence of the mediator is not an award. All right. It is not a decree which says that something has to be paid. It is basically a contract promising compensation. That's it. All right. So if, let's say, this contract is not honored, then again you can go to the process of arbitration, or in such cases what happens is that it goes into litigation. So because the mediator listens to each party in the absence of the other, it risks the disclosure of information of one party to the other. So in the sense of, righteousness for justice for both the parties, it is not advisable that either one of them knows what the stand of the other party is. So if they end up knowing it, what happens is that they gain a certain amount of leverage over the other party. Okay. And this also breeds doubt about the integrity of the mediator because of the disclosure of information. All right. Because once information is disclosed, which may influence a case, it automatically turns in the favor of the person who's able to manipulate that information. So in that sense, mediation is not a good method to bring about a compromise between two parties. The next thing that we will look at is conciliation. So it is a process alternative to arbitration, and it largely resembles how arbitration works. The difference primarily lies in the fact that the conciliator has a vested interest in the continued association between the two parties. All right. In the case of arbitration, what happens is that the arbitrator is perfectly all right if the two parties do not continue working together after the arbitration proceedings. But in the case of conciliation, what happens is that the person who is brokering a truce over here has a vested interest in the continued association. All right. The conciliator must possess relevant expertise to the subject in discussion and a vested interest, but he should not have emotional ties to either parties. Basically, what happens is that if you have an emotional tie, you are liable to be biased towards that party against the other. Also, the conciliator must not consider himself as above the two parties, and he must not be under the dictates of either party. We already talked about that as a part of the emotional ties. All right. Basically, what happens is that this ends up coloring the entire exercise of conciliation, and it basically favors one party over the other. We take up conciliation. The process of conciliation is taken up rather when the disputing parties themselves or others with vested interests in the association between the disputing parties, intervene on behalf of these people to ensure amicable settlement of differences, so that the association can continue with no bad blood or ill will. Now we come to the point where we discuss why people prefer mediation or conciliation over arbitration. Mediation is a quasi form of arbitration. It still falls outside the ambit of law. An agreement of mediation is merely a contract and not an enforceable order, as we already discussed. Right? And conciliation is based on the tenet of brokering a compromise between the disputing parties. Correct? So, both these processes are indicative of willingness of the disputing parties to not let past differences get in the way of working together again. So the idea of both of these is to say that, okay, fine, we have had a disagreement in this particular activity. Perhaps in the future we should be able to reconcile and have a smooth working relation. In the case of arbitration, there is an unresolvable point of conflict between the two parties, which has affected their capacity to work with one another. Thus, the need for arbitration. At the end of the arbitrary award, the parties may choose to complete the promised work, but end their relationship owing to a lack of mutual trust, leading to the initial arbitration proceedings. All right. So while the provision is made as a part of the contract, the idea of the contract itself is that there is some basic understanding or goodwill between the two parties, and that is why they have started coming together as a part of the work. To actually initiate arbitration proceedings indicates a lack of mutual trust. So what happens is that the two parties may either walk away from each other immediately after the arbitration proceedings, or they may choose to complete the work, but they will definitely end the relationship. All right. So that was it for part one. So what I will do is this video as well as the PowerPoint slideshow will be uploaded as a part of the classroom. In a short while, we will also be given access to the second part of this lesson. Okay. So at the end of this, we will be setting up a couple of assignments as a part of the classroom. Okay. Thank you all and see you shortly.